Well, good morning and welcome to Sunday Morning Coffee with Dr. Childress. Today, I'm going to be discussing licensing board complaints and obtaining accountability from the mental health system relative to professional competence. And to begin with, I just want to say that it's not up to parents to acquire competence. It's up to the mental health people and the mental health system to provide competence. That's our obligation. And so we should be providing you parents and your children and the courts with competent mental health services, and we're not. And so that puts you, the parents, in a position where you have to then seek competency. And so that's what we'll be talking about today. But that's really an aberrant situation based on the failure of professional psychology. So, let me, yeah. So let's talk about accountability and particularly licensing board complaints and malpractice lawsuits. Now, I'm not a lawyer, so I'm just offering from the professional psychology side, the foundations for accountability. To begin with, the issue is forensic psychology. Forensic psychology is a failed experiment in service delivery to a vulnerable population. And if it succeeds, if these forensic psychologists create this new model for service delivery that succeeds and helps families, then the developers get, of this new experimental approach, get all the financial rewards and career status, which they have been doing. They're getting paid, they're getting all the financial rewards and career status from having developed this experimental approach. If, however, their experimental approach to service delivery fails, then the lives of thousands upon thousands of children and their parents will be irrevocably destroyed. And the problem is they failed. 40 years, we've had an extensive look at it, and forensic psychology is a failed experiment in service delivery. And as a result, the lives of thousands upon thousands of children and their parents have been irrevocably destroyed because of their failure. The forensic psychologists obtained all the financial benefits of their experimental new approach, while the children and parents bore all the costs in destroyed lives. And that is simply unacceptable. From a professional psychology standpoint, we did a very bad thing to you parents and to your children by experimenting on you. And one of my largest complaints about that is that the forensic psychologist never informed the parents or the court or about alternatives to their forensic custody evaluation. They never informed the court about or the parents about the possibility of a clinical diagnostic assessment relative to child abuse, relative to the pathology, and coming up with a treatment plan. We need a diagnosis for a treatment plan. But they never offered that option to the courts or to parents. They offered only their one approach, which was an experiment developed by specific people. And if it works, great. If it doesn't work, uh-oh. And the costs should never be borne by the recipient, where the benefits go to the psychologists. That is extremely problematic. So, to begin with, this is not simply my opinion. An outside independent review of forensic custody evaluations in New York, the New York Blue Ribbon Commission on Forensic Custody Evaluations, found that ultimately the commission members agree that some New York judges order forensic custody evaluations too frequently and often place undue reliance upon them. Judges order forensic evaluations to provide relevant information regarding the best interests of children, and some go far beyond an assessment of whether either party has a mental health condition that has affected their parental behavior. And that gives an indication of what the court is seeking. It's what the court is seeking is whether either party has a mental health condition. Do we have a shared persecutory delusion? Is this a factitious attachment pathology? Is this child psychological abuse? Those are the questions for the court. The court can decide on custody on its own. It doesn't need psychologists to tell the court what the custody schedule should be. The psychologist should be informing the court about what any mental health condition should be or in the family. They go on to say, in their analysis, evaluators may rely on principles and methodologies of dubious validity. In some custody cases, because of the lack of evidence or the inability of parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny and are often accepted by the court, with potentially disastrous consequences for parents and children. And I want to emphasize that potentially disastrous consequences from these defective reports that rely on dubious constructs or dubious validity. And this is a serious problem with these forensic custody reports. I am the meaningful scrutiny. That's my current role in the family courts. I'm a second opinion on these forensic, so I get to read them. And I am 100% in agreement with the New York, based on my review of them. And so if you get an outside independent review of these forensic custody evaluations, there are serious, serious problems. The problem is they are allowed to self-review. And so that's the conflict of interest here that professional psychology is in. There are specific people with names who are intentionally disabling the mental health system response to the pathology in the family courts for their own financial gain and career status benefits. I know who they are, and they're pretty easy to locate. You just look at the top rung of forensic psychologists, and I'm firing a shot across their bow to stop disabling the mental health system and readjust how we approach the pathology in the family courts, because if it keeps going forward, we're going to start naming names and moving these people out of their positions so that we can get an appropriate mental health response to the pathology in the family courts, to the child abuse and spousal abuse in the family courts. So, the Blue Ribbon Commission goes on to state, by an 11-9 margin, a majority of commission members favor the elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence or child abuse. Holy Toledo. Okay. This is an independent review. I am in 100% agreement with it. We favor the elimination of forensic custody evaluations entirely. And that if it happens in New York, I suspect Colorado's looking at some stuff. Southwest, Florida is more on the legislative line, but any state, every state needs to start reviewing this process and looking at whether or not forensic custody evaluations should be eliminated entirely. And the answer you're going to come back with is yes, because they are harmful to children. That's not me saying it, Blue Ribbon Commission. They lack scientific and legal value. That's them saying it, not me. And they're dangerous. That's them saying it, not me. And I will say exactly the same thing based on my review of these abominations. These members reached the conclusion that the practice is beyond reform and that no amount of training for courts, forensic evaluators, or other court personnel will successfully fix the bias, inequity, and conflict of interest issues that exist within the system. There are substantial conflict of interest issues. We need outside and independent. Problem is, the forensic psychologists are in the positions within the APA, within the licensing boards, within that outside review people. And so they are disabling any sort of critical review or scrutiny of what they're doing. It's really bad over here. The forensic custody evaluators are in violation of multiple standards of the APA Ethics Code, including Standard 2.01 Boundaries of Competence, 2.04 Bases for Scientific and Professional Judgments, and Standard 9.01 Bases for Assessment. I discuss these a lot in a variety of different places. The appellate system, such as the licensing boards, will not retry the facts of your case. So if you're a parent, don't think you're going to provide them with the information about your particular situation, and they're going to say, "Oh my gosh, this custody evaluator made a bad decision on this situation." No, that's not what's going to happen. It's like a trial judge. They're the trial judge, and they make whether they determine something. Finding a fact, that's what they determine. The issue for the appellate system is focused on the procedural issues involved and the professional practice violations. So the ethical standards would be directly relevant to an appellate kind of review. So when you make a board complaint, focus your complaint on their violations to ethical standards of practice and on their failure in their duty to protect obligations because they're not competent. And they this is child abuse. They didn't do a proper assessment for child abuse. So stay focused on those domains rather than the individual facts of your case. You can use the facts maybe to support what you're saying, but keep your focus on the practice issues. So the issue that I recommend you focus on is the issue of competence. That's what we need from the mental health people. And that's their obligation. It's up to them to be competent. It's not up to you to acquire it. That's an obligation before they even come into work in the family courts. They need to be competent. That's not learn on the job. And so they need to be competent in the diagnostic assessment and treatment of delusional thought disorders. There's your Walters and Friedlander quote. If they know it's a possible delusional thought disorder, and they do, then they need to be competent in the diagnostic assessment and treatment of delusional thought disorders when they are assessing and treating a possible delusional thought disorder. That's like logic, clearly evident that that's a requirement. They need to be competent in the diagnostic assessment and treatment of attachment pathology when they're assessing and treating an attachment pathology. And they need to be competent in family systems constructs when they're assessing and treating a family conflict. So there's 3 domains of competence, and I guarantee you they're not competent in any one of them. Competence you will notice on their vita. You can look back on their vita, and it should say where they have this training and experience. They don't have any training, and if you look, there's going to be a long list of history of forensic custody evaluations. Mostly private practice. That'll be what their vita looks like. They won't have competence in these domains, and this is what we need. If we are doing open heart surgery, we need somebody competent in open heart surgery. Now, personally, I have mandatory obligations, ethical obligations under Standard 1.04 and 1.05 of the APA Ethics Code. And so these are the standards that are governing my actions. And I want to be real clear to people right now. That's what's governing what I'm doing. People see me potentially as like somebody who's out, leading a movement or having new theory. No. I'm responding to ethical standards to 1.04 and 1.05. Let me pull it up for a second, make a point. The APA Ethics Code is mandatory. It is required of all psychologists. Ethical standards are not optional. Okay, so standard 1.04 and 1.05 are mandatory for me. Okay, so that's what I'm doing, is I'm responding to my mandatory required obligations under 1.04 and 1.05. As soon as we fix the pathology in the family courts, I'll go do something else. But until that happens, I have obligations. And, top off obligation is 1.04. It starts with that, which is informal resolution of ethical violations. When psychologists believe that there may have been an ethical violation, so notice a low bar on that. I don't even need to prove that there is one. I just have to believe there may have been one, and I can guarantee you, I read the reports, yes, there are ethical violations by another psychologist. They attempt to resolve the issue by bringing it to the attention of that individual if an informal resolution appears appropriate and the intervention does not violate any confidentiality rights that may be involved. So basically, if you're worried about somebody has ethical issues, don't run to the licensing board right away. Go, take it to them and talk with them and see if you can help provide some guidance. So that's 1.04. Is see if you can handle it informally between. However, you have to do something. Okay, you're not allowed to just ignore. If you think there's an ethical violation, you have to take action and contact that person and say, hey, I'm worried about what you're doing. Now, 1.05 is the one that's governing me in the family courts, because 1.04, I can't contact all the forensic psychologists informally. It's not appropriate for that. I do want potentially when I'm involved in individual cases, but typically I allow my report to satisfy standard 1.04. I figure they're going to get notified when they see my report regarding my ethical concerns. But for me, governing my practice in the family courts is standard 1.05. And notice the APA ethics committee people came up with two separate, they didn't put it one standard with two parts. They gave it two complete standards. That's how important this issue is. And we'll talk about that a little bit going forward. So with standard 1.05, if an apparent ethical violation has substantially harmed, yes, it has, or is likely to substantially harm, yes, it will, a person or organization and is not appropriate for informal resolution under standard 1.04, no, it's not, or is not resolved properly in that fashion, no, it hasn't been. So all of those clauses are met for me. So 1.05 is active, mandatory, required of Dr. Childress. Psychologists, Dr. Childress, take further action appropriate to the situation. Well, what is further action appropriate to the situation? That's a broad kind of mandate for me to do. And it gives some suggestions. Such action might include, not necessarily, but might include referral to state or national committees on professional ethics, to state licensing boards, or to appropriate institutional authorities. Now, my question becomes, what happens when I do that and the licensing boards, the national committees on professional ethics, and the other institutional authorities like the APA do not take action? Well, then it was not properly resolved in that fashion. So then what happens? I'm doing my job. I'm informing and the parents are informing the licensing boards and the APA about what's happening here, the ethical violations, and it's the APA and the licensing boards are not responding. What do we do then? What's my appropriate act or action appropriate to the situation when that happens? It is to continue to do the right thing, to continue to inform the APA, to continue to inform the licensing boards, and that will allow their inadequacy, the problems within the system of the APA, the self-review system, and the licensing boards to become evident. And the problem is they are both infected by the forensic psychologists who are disabling both systems. The forensic psychologists in the APA are disabling that response, and the forensic psychologists on the licensing boards are disabling that response. So as soon as we clear them from the system, we will get an appropriate mental health system response to the pathology in the family courts, and we will fix it. But we have to get these specific people out of their decision-making and out of not reviewing and not recognizing the problems in forensic psychology, because the moment they do, they're out of a job. They've been here for 40 years doing these forensic custody evaluations. The moment they acknowledge that they don't work and that they're harmful to children and that they're dangerous and they lack scientific and legal value, they have to go do something else. And they've also been unethical for 40 years, and they've also been participating in child abuse for 40 years. So their career goes whoop. So there is a substantial motivation within the forensic psychologist to not recognize and to not change the situation. But that's not a long-term tenable solution. That it's not unethical practice. It's just simply not okay. And competence, incompetent practice. We need competence in the family courts. And forensic custody evaluations are failed. New York Blue Ribbon Commission. We need change. We need to solve the pathology in the family courts. And so these people who are disabling the licensing board response and the APA's response need to be identified and gone. And so by continuing to do the right thing, so for me, it's 1.05 and fulfilling my obligations here. And for you, it's to hold them accountable for when they're unethical or incompetent. Do the right thing. Tell the licensing boards, start contacting the APA and asking for that they provide competence. Not that you have to seek it, that they provide it, that they take an interest and start caring about this stuff. So further action appropriate to the situation for Dr. Childress is that I am empowering parents to make reports to appropriate state or national committees on professional ethics, to state licensing boards, or to the appropriate institutional authorities pursuant to my obligations under Standard 1.05, and to discharge my duty to protect the children and their parents from substantial harm. So I'm discharging it to the licensing boards and the APA. That's who now has duty to protect obligations. Because I've told them, I'm getting parents to tell them that this is happening here, and they are just simply ignoring it. So licensing board complaints. First off, don't expect that any action is going to result from your board complaint. It's not. The forensic psychologist will cover up the unethical malpractice of other forensic psychologists because they all do the same thing. The moment they acknowledge they're incompetent or unethical, then they're all doing it. And so they'll all get in trouble, and they'll all be in the same situation of having to leave and get their careers gone if they do that. So there's a cover-up. Now, let me explain how easy it would be for the licensing boards to address this. All they have to do is hold a couple of seminars for forensic psychologists. Just decide that this is a problem of competence. You're getting a lot of these complaints about competence and delusional thought disorders, attachment pathology, and family systems. Well, you know what? Let's make sure we're not going to individually sanction the psychologist. I don't know why, but we're not going to do that. But let's at least do seminar trainings to get them competent. But the moment the licensing board, any licensing board, held a seminar to improve the quality of forensic custody evaluators in terms of competence, they are acknowledging that that's an issue or a problem. And then the moment they acknowledge that, you potentially have all sorts of malpractice suits coming in if the licensing boards are recognizing it's a problem. So they cannot acknowledge. The forensic psychologists have a personal self-interest in not acknowledging their failure and their incompetence. But that's the problem. So it's very much, very, very similar to the Catholic Church and the sex abuse scandal. That's what professional level psychology, the APA and the licensing boards need to evaluate at this point, because we're going to have a tremendous scandal coming through on these forensic custody evaluations, Blue Ribbon Commission. And they were a failed experiment, and there's some really serious problems with what happened. And there needs to be some self-reflection from APA and some other people about how this was allowed to occur. But it's coming. And so trying to cover it up is not a good solution. You're going to get in more trouble for the cover-up than you will for the actual issues, which are substantial. But don't try to cover it up. And the forensic psychologists are highly motivated to cover it up. And so the clinical people who are not in the family courts, who are in positions of authority within the licensing boards and within the APA, need to take this issue seriously and get some eyes over here on this issue. So, licensing boards are corrupt. That's a powerful statement, but I'll stand by it. The licensing boards in professional psychology are corrupted by the influence of forensic psychology within them, and they do not enforce ethical standards of practice for forensic psychologists. Now, they are not corrupt with all the other domains: ADHD, autism, eating disorders. You pick a domain of psychology, licensing boards are very tough, very good. But with forensic psychologists, they just give them a carte blanche to self-review, and they're just awful. And they don't, and so we got to cover up by the forensic psychologists. So licensing boards need to do a sort of self-exam. And I would just recommend that you just start doing seminars on assessment of delusional thought disorders, assessment of attachment pathology, diagnosis for forensic psychologists. And I would suggest we just get rid of custody evaluations and go back to clinical diagnostic assessments. But do not expect, if you file a licensing board complaint, do not expect the licensing board to take action on your complaint. What you're doing is you're doing the right thing. Let outcomes take care of themselves. There's a cover-up. Expect the licensing boards to cover up for the unethical malpractice of other forensic psychologists because they all do exactly the same thing. Make the forensic psychologists on the licensing boards, however, cover up their unethical malpractice over and over again, and then bring your state legislator as to why the licensing boards are not enforcing ethical standards of practice. And so if you get in a state, if you get multiple constituents going to their state legislators, all with the same message about competence and where's the licensing boards, get your state legislatures to oversee what's going on in the licensing boards. Let's hold some committee meetings about what's happening in the licensing boards here, because I'm getting a lot of complaint from my constituents about the lack of ethical standards and competence in forensic custody evaluations. Okay, so that's the series. So don't worry about your individual matter. We're working for each other just to bring competence to the family courts. The licensing boards are typically within the Consumer Protection Agency of the state. And so their role is supposedly is consumer protection. The state licensing boards are supposed to protect consumers from unethical malpractice by psychologists. Instead, the licensing boards are protecting the unethical psychologists from accountability for their unethical malpractice, to the substantial harm of the consumer. So, question, you don't believe me. Why do you think it's so bad over here? Why can't you get competence? A patient should never have to explain the pathology to the doctor, but you're having to explain what the pathology is to the doctor. How bad is that? And why is it so bad here, but not with autism, not with ADHD, not with eating disorder, not anywhere else? Just in the family courts. Who's responsible for ensuring ethical standards of practice? The licensing boards. Well, they're failing. That's obvious. Why are they failing? It's not because they are bad. It's because the forensic psychologists have infected the system and are disabling the mental health system response to the pathology in the family courts. That is the fundamental problem. And they are specific people, and they have names. Malpractice. When we shift over to malpractice, and that issue, again, I'm not an attorney, but the malpractice issue is a failure in the duty to protect. You also have the ethical standards, and so we have multiple malpractice violations, but the primary one is the failure in duty to protect, whereas the board complaints, the primary argument is the ethical standards, plus you have failure in their duty to protect because they're not competent and because they didn't conduct a proper assessment of stuff. So the legal options for malpractice, from a psychological point of view, as a psychologist, is that one of the features is that licensing board complaints are free to the consumer. So you can do that because they don't want any barriers to informing and getting competent ethical professional practice. But malpractice lawsuits require an attorney's involvement, so they're going to cost money. So that's why probably they haven't been generated up till now. The malpractice litigation, however, can also result in damages awarded. And the potential is, I think all you parents have malpractice valid complaints against the forensic psychologist. But I would also argue that you're a class of people in the family courts, vulnerable population and stuff. So I would think there's a class action lawsuit as well as that. Now, in terms of what's happening on a malpractice lawsuit, one of the difficulties in getting malpractice against doctors is getting other doctors to testify. And or like police officers, they all kind of close ranks when they're attacked. And so that if you attack a doctor, all the other doctors will close ranks. I'm in the position of what's considered a whistleblower. So, when forensic psychology closes ranks, I'm not part of them. So I will identify exactly where their problems are. As a result, I will face retaliation from the forensic psychologist for exposing their unethical malpractice. That is a fact. It's very dangerous for me to be in the family courts right now because the forensic psychologists want me gone and they will retaliate against me. But with the malpractice lawsuits, I would look to the Tarasoff as my model. Now, Tarasoff's a little bit different. That was a determination about duty to warn. Okay, so we have duty to warn, and it's about homicide, but was based on duty to protect. And who do we have to protect? Just a client, or do we have society in general? We have to do stuff to protect society in general. Is Tarasoff. Now, I would categorize this in the same domain, that we have a failure in the duty to protect obligations in the family courts because of how these forensic psychologists view their thing. And so that would be the malpractice, would be failure in their duty to protect, and it goes to negligence, failure in duty. So that's where, and again, I would look to a class action lawsuit rather than just a single person, because it's being done to you by everybody. And there's actually heads of things like the, AFCC that organizes the forensic custody evaluations and gives them to the court, and the APA is colluding with that, and the licensing boards, and everybody in the systems is giving you only one option, and is not giving you competence in anything. And so these folks are failing in their obligations. And it's for their own financial gain of the various people who are doing this. So I think you could likely have a class action on that. But I'm not an attorney. What do I know? Negligence. Let's talk about negligence for a second. Google negligence. Definition: failure to take proper care in doing something. Yep. Forensic custody evaluation. Failure to conduct a proper risk assessment. Failure to conduct a proper assessment for delusional thought disorder when they know that's a possibility. Failure to take proper care in doing something. Here's from the Cornell Law School, their definition of negligence. Negligence is a failure to behave with the level of care that someone of ordinary prudence would have exercised under similar circumstances. The behavior usually consists of actions, but can also consist of omissions when there is some duty to act. So again, the duty here is the duty to protect. And I'm a clinical psychologist, so I'm your baseline of what a normal clinical psychologist would do in that situation whenever we encounter suicide, homicide, or abuse. Those are the dangerous pathologies. Duty to protect obligations are activated, and we have to either conduct a proper risk assessment personally, or we have to ensure that a proper risk assessment is conducted. That's our obligations relative to when we encounter any possible dangerous pathology. There's 3 of them: suicide, homicide, abuse, child abuse, spousal abuse, or elder abuse. Any of those, duty to protect. Now, forensic psychologists, the only cause of severe attachment pathology is child abuse by one parent or the other. So we have possible spousal abuse using the child as a weapon. So their duty to protect obligations are active. Did they conduct a proper risk assessment to the differential diagnoses? We got possible persecutory delusion, possible psychological child abuse. Did they look at it? Proper care? No, they didn't. There's your negligence. So I don't know why you guys can't come up with these lawsuits on this stuff, because it's pretty clear they're in problems. And if there's an attorney who wants to develop a private practice in malpractice lawsuits in the family courts, get a hold of me. I'm more than happy to give you guidance on the professional practice issues involved. You'll probably get a lot of business if you are doing that. And you don't need to do that. That's the problem with malpractice lawyers too. If you try to do this option, because they're malpractice lawyers and they don't know the family courts. And you don't need 1,000 malpractice issues. You just need this particular one. And so it's a very targeted and focused domain of practice for an attorney. So now let's talk about appropriate institutional authority relative to that. And what does that mean? Because these are the things that I'm required to do. So the standard 1.04 says licensing boards. Okay, that's an appropriate institutional authority to refer you to. And I would also note the ASPPB, the Association of State and Provincial Psychology Boards. This is the larger organization that coordinates and works with all the different licensing boards from all the different places. So not only do you have a licensing board, but you have the oversight of the licensing boards. And overseeing the licensing boards are the state legislators, and the state legislators represent you. So if there's a problem in the licensing boards because of the infection of the forensic psychologists disabling the mental health system, then the state legislators can take a look at that and see if the licensing boards are functioning in the way that they had intended. And no, they are not. And so what adjustments can be made to acquire professional competence for the people in the family courts. And then the American Psychological Association, I would say, is another appropriate institutional authority. They're the ones who give us psychologists. And I would argue that for the APA, similar to licensing boards, they have an obligation to take proactive steps, given the situation, to ensure that the families in the family courts are receiving competent professional services. And instead, they are neglecting. They're negligent. They're not showing proper care relative to ensuring that the parents and children in the family courts and the court itself gets appropriate competence in mental health services that we deliver. They just don't care. They're negligent in their obligations relative to that. And I would say, noted that the negligent relative to what they provide, the quality of services they provide to parents and children in the family courts, also that they provide to the court, to the legal system. The APA, the American Psychological Association, is negligently deficit in the quality of professional services that they are providing to the courts. And so if I was sitting on the Bar Association, the American Bar Association, I'm going to call over to the president of the APA, say, why are you giving us such low quality mental health services in the family courts? Our judges need diagnoses. Our judges need treatment plans. Our judges need these things fixed. Can you please send us some good psychologists who can give us accurate diagnoses our judges can rely on, and effective treatment plans that get this nonsense out of the courts? Please, APA? And so, because the APA is just failing massively in their obligations. And I've told them, and they have, all the psychologists in the APA have the same ethical obligations under 1.04 and 1.05 that I do. So why aren't they acting to 1.05? I don't know, but I'm going to find out ultimately. So I would hope that they would adjust what they're doing before we continue on and start exposing the cover-ups and all the other nonsense. And within the APA, just be aware there's Division 41, American Psychology Law Society. Those are the forensic psychology people. Oh my goodness! But tell them that's their domain. And then the APA Ethics Committee. And on the APA Ethics Committee, they're an interesting group. I'll be getting a hold of them at some point. That's on my to-do list, but I'm working my way up to it. If they activate sooner, yay. But if they don't, it's just going to keep going. And because these are accurate uh, violations, the forensic psychologists are in violation of multiple ethical standards, including Principle D, justice, that ensures that equal access and equal quality. Principle D, justice, equal access, equal quality. Forensic custody evaluations violate both aspects of that. They, but their expense nullifies equal access, and there's no inter-rater reliability. They have no equal quality. They're in violation of a very ethical principle of practice. And so the AP Ethics Code or Ethics Committee is a relevant place to turn for that. So the goal here is for parents. The parents want competent mental health services in the family courts that result in an accurate diagnosis and effective treatment for their children and families. That's the goal. And it's not to get people in trouble. It's not to retaliate. It's not. Parents just want competent professional services in the family courts. And look how hard it is for them to get that. Where are the licensing boards ensuring that they get professional competence to the consumers? Where is the APA providing, ensuring that these families in the courts and the court system gets competence? Nowhere to be seen. Does that strike you as odd? They do it everywhere else. We get competent services in ADHD, autism, schizophrenia, everywhere else. Why not in the family courts? Because the family courts have their own special psychologists. No other domain has special psychologists just for you. Well, guess what? They're the problem. They are disabling the mental health system response to the family courts. And so that needs to be addressed. And it will be addressed. And sooner or later, hopefully the powers that be understand sooner. But going forward, I'm going to wrap up here, but going forward for you parents, don't worry about the outcomes. Okay? This is a difficult time for everybody, and things. Keep a clear perception of where you are and what we need to accomplish. You just do the right thing. I'm doing the right thing. Standard 1.04 and 1.05. I'm just following along. And that points out the power of the APA ethics code, of the ethics standards. And the people who wrote those standards knew what they were doing. And the standards 1.04 and 1.05, two of them, they gave them two for exactly this situation. That one psychologist, Dr. Childress, if I follow the ethical standards of the APA, will fix the problem in the family courts, because the problem's in unethical practice by the other psychologists. And so 1.04, I'll inform them, but that's not doing any good because they have a variety of personal motivations, financial motivations to cover up and not change. And so then 1.05. And then they disable the mental health system response in the APA and the licensing boards. Well, then I educate you on what I'm supposed to educate you on, which is filing board complaints and getting a hold of the appropriate institutional authorities and making them aware of the problem situation. So we just continue to do the right thing, and that'll allow other people in the other systems to organize around the right thing to do, which is ethical practice and competence in the delivery of mental health services. So with that, I'm going to head off to my Sunday here. Good luck, everybody, and we'll talk to you over coffee next week. Bye-bye.